for digital securities. Then we have Hin. Hin is a non-stipendiary lecturer of private law at Oxford. He's currently a legal advisor at Fusang. He's finished his MPhil, which was looking at the link between the token and the off-chain asset. And he's about to start his DPhil, continuing to explore those issues. And then, of course, we have Louise. I don't think I need to introduce Louise to you all. Louise obviously now is the Rouse Ball Professor of English Law at the University of Cambridge. So we've got three presenters, and then Guy Morton is going to be the commentator on this paper. Guy, as you all know, prior to his retirement, was a partner at Freshfields, Brookhouse Derringer, has been deeply, deeply embedded in all of these issues for many years now. And he's very well placed, I think, to comment on these issues. So I don't know which of the three of you is going to kick off, but Louise, you're going to get started. Okay, over to you then, yeah. Louise.
So my job is to introduce the paper. So I'm going to just tell you a bit about why we've done this paper. It possibly doesn't have, it's a little bit more, I don't know, meant to be useful to the market rather than some of the papers we've had, which have been more to do with the way that law should be shaped. All we're trying to do here is think about the analysis of law and how it applies in the actual markets. But as Jenny said, we're moving towards the custodial. We're going to now think about the custodial situation, the relationship between the intermediary and the investor. Okay, so the impetus for this paper came from a number of sources. Henry, as you may know, has been involved with digital assets at the sharp end, running a custodian and an exchange. And last year, those of you who were present at the meeting, which was, thank goodness, an in-person meeting last year, you'll remember that Henry and Chuck Mooney, who has now joined the call, hello Chuck, Chuck was in Japan, Henry was in Oxford, and they did what we thought was amazing, which was to run a paper run by two people in different places. But of course, now we're doing it all the time. And their paper was called The New Intermediation, and it was looking at intermediation and custody in a very specific way. So this, in a sense, it moves on from this in a rather more specific area. The second impetus, and perhaps more importantly in terms of this paper, is that the disjunct between what people who are actually involved in the digital assets market think is going on when assets are held by a custodian, and giving expression to that in law, giving expression what is happening in law. Now, I should say that our paper is basically about common law. We don't really address civil law questions at all. So we move now from the civil law to the common law. Now, one answer to the question is, well, that's easy. We can tell you what the legal analysis of a custodial relationship is. Just look at the contract. What does the contract say about it? That will tell you what the analysis is. But at least at the moment, contracts tend to be silent on that issue. They don't say anything about a legal characterization. They sometimes, well, they will describe some aspects of the relationship. They'll probably exclude as much liability as they can get away with, but not actually characterizing the relationship. And even if they did, even if a contract did that, the question is then, would that be upheld by a court? Or would a court take the view that the incidents of the relationship as set out in the contract are inconsistent with the label put on that relationship in the contract? And those of you who are English lawyers will be very familiar with the Brumark and Spectrum cases in the context of fixed and floating charges, which make it clear that at least in English law, if you call a spade a fork, the court will still hold it to be a spade. Two other impeti, whatever. One is the relationship which we already mentioned between custody of digital assets and the intermediation of securities more generally. And as you know, Jenny and I edited a book on all of this, and many of you have been involved in thinking about that. And the last is the happy coincidence that Hin, who was my former MPhil student, is now working for Henry. And so Hin has done a lot of the heavy lifting on this paper, and we'll do some of the discussion of the middle part. So what we're seeking to do, this paper, as I say, is going to be quite functional, because the idea is to have a short version for the market and then a longer version for legal specialists, academics, judges and practitioners. And the idea is to set out the possible analyses as we see them, and to identify the features which will need to be present in any given relationship for it to fall within one or other of those possibilities. The conclusion, which we will come to at the end, is that most custodian relationships are likely, sorry, can you just go back, Henry, to the list? Sorry, are likely to be analysed as creating a trust, at least obviously in the common law jurisdictions. And Henry will go to address that conclusion and talk about the regulatory implications, and Hin will provide the private law analysis of the various possibilities. So there are, we see, 4 possibilities, and bearing in mind when we talk about common law jurisdictions, we're not really talking about jurisdictions such as the US, which may have a statutory or some kind of legislative code which analyzes the holding of securities and that kind of thing. We're just talking about a situation where we're talking about private law and common law. So first of all, outright title transfer, what it says on the tin. No, sorry, Henry, can you still go back? I'll come back to the flowchart.
Sorry.
With an outright title transfer, the custodian becomes the owner of the asset and the client just has a personal right against the custodian, like in a banking relationship, Foley and Hill. Now, apart from the considerations that Henry and Hin are going to discuss that flow from this, this is also very bad news for the client if the custodian becomes insolvent. The analysis of outright title transfer basically means that the client who thinks that they have some asset actually only has a personal right against the custodian, which of course is going to be terrible if it's insolvent. And this analysis, this outright title transfer analysis, was rejected in the Cryptopia case in New Zealand, and that was of course much to the delight of the clients whose Bitcoin was held by Cryptopia, and much to the despair of the other creditors of the custodian who recovered very little. The second possibility is trust. In other words, the custodian holds the assets on trust for the client. That will mean under common law that the legal title will be in the custodian and the client will have a beneficial interest in the asset. This is the analysis that has been held to apply to intermediate securities under English law. And I mean, one of the benefits of a trust is it can be applied to any type of asset as long as it's property. So it can be tangible or intangible assets. And of course, it protects the client in the event of the intermediary's insolvency. The third possibility is bailment. And perhaps I should say immediately we're thinking of something like quasi-bailment, because real bailment, at least English law, is to do with tangibles. So if I have a block of gold and I give it to Jenny to look after for me for safekeeping, she's my bailor and I'm the bailee. If she becomes insolvent, I just go and get my gold because it's my gold. I have ownership, she has possession. Now that analysis can describe a digital asset customer relationship, but it doesn't work in at least one respect, leaving aside all other questions, and that is that at least under English law, no one can possess digital assets because they're intangible. So the paper also thinks about, well, can they? Can you have some kind of bailment without possession? Or would a better concept be some kind of quasi-bailment with some other factual relationship between the custodian and the client, such as control? And then the fourth possibility is that there's just a contract. There's no bailment, there's no trust, there's no transfer of title. It's just a contract between an investor and an intermediary. The client owns the asset. They can sue the custodian if something's happened and the custodian's in breach of contract. And so the question is that what the parties really intend? Is that analysis, would that be upheld by the courts, even if all other analyses were excluded by a contract? Now I would like the flowchart, if that's all right, Henry. We have put together this flowchart, or rather Hin and Henry have put together this flowchart, which I need to look at in hard copy because I can't read the small screen. And the idea is that these are basically to put a picture, a pictorial representation for presenting this kind of analysis to the market. The questions themselves are not easy to answer. And in fact, most of the discussion goes to how you answer the questions as well as what the questions are. But you start off by saying, does the intermediary have legal title to the asset? And if the answer is yes, there are two possibilities. One is outright title transfer. So the intermediary will then own the asset outright. The second is that it will be held on trust. And in order to be held on trust, the three certainties must exist. Intention, certainty of intention, certainty of subject matter, and certainty of object. And Hin will explain that further. If those three certainties don't exist and legal title has been transferred, there's an outright title transfer. If the intermediary doesn't have legal title, then there's either some form of transfer of possession, in which case it's a bailment or something like possession, like a control, it would be a quasi-bailment. And if not, it's just a contractual obligation. One example, I think Henry might talk about this, for a contractual obligation is where the counterparty merely licenses software or sells hardware which enables a client to store its private key online or offline. Offline, I suppose, and then that would just perhaps be a contract and not any kind of another analysis. So you can see from that the schema of what we're trying to get across to the market. And now I'm going to hand over to Hin, who will talk about some of these possibilities in more legal detail.
Thanks, Louise, for the very kind introduction. So as Louise has mentioned, there are 4 possibilities in analysing the relationship between the investor and the intermediary. It's outright title transfer, trust, bailment, and a mere contractual obligation. It's important to recognise that these are just default categories, meaning that parties can modify the set of obligations which attach to each legal arrangement or category. But at the same time, there's a limit to how much of this party autonomy or tinkering by the parties can be done, as will be seen when we discuss the trust later on. As a preliminary but very, very crucial point, we have to distinguish between legal arrangements where the intermediary gains proprietary rights to the assets and also arrangements where all proprietary rights stay with the investor. This is because the rights of the investors would be they'd be drastically different. So the first 3 arrangements, outright legal title transfer, trust, and bailment, carry such proprietary effects where the intermediary gains proprietary rights to the assets, whereas a mere contractual obligation does not carry such proprietary effect as the name of the category suggests. So let's explore the 4 categories in turn. So first, there's outright legal title transfer, where legal title is vested absolutely in the intermediary. So the effect of this is that the intermediary can freely dispose of the assets it holds. It's the absolute owner, and it's not under a duty to use the asset for the benefit of the investor. And this has consequences in terms of insolvency and tax treatment. So when the intermediary goes insolvent, the investor wouldn't have any entitlement to the asset, and in relation to tax, it's the intermediary who will be subject to the applicable tax regime, meaning that, for example, capital gains tax would not be levied upon the investor, but rather the intermediary. So how do we decide whether something is an outright title transfer? We look to the intentions of the parties, and we look for the intention as discerned from the investor-intermediary agreement. So the initial agreement that they enter into in constituting this custody relationship. So if we find an intention that full legal and beneficial title is to be transferred to the intermediary, then title to the asset will vest in the intermediary as long as the relevant formalities of transfer, if any, are complied with. And this is what David was talking about in the discussion in the last presentation. So this depends on the type of property. For example, for shares, they might have some formality requirements that transfer, whereas for different kinds of chattels, they don't necessarily have such requirements to transfer. And so it very much depends on what the asset is, whether it's an exogenous or an endogenous asset. And also, if there is an outright title transfer, it would be expected that the asset shows up on the balance sheet of the intermediary. And the fact that the asset does show up on the intermediary's balance sheet is a strong indicator of an intent to transfer title, so this inference works both ways as the intermediary is treating the asset as its own. But although in principle the intermediary can freely dispose of the asset, this is again just a default position, and there would most certainly be contractual obligations owed by the intermediary as a result of the relevant custody agreement. So this would modify the legal position in that the investor would have personal rights against the intermediary. So apart from holding the asset absolutely, the intermediary could also hold the asset on trust for the investor. And for this to be the case, legal title must be in the trustee, and the 3 certainties for creating a trust need to be satisfied, and this is the position under English law. As we know, the 3 certainties under English law are certainty of intention, subject matter, and object. And so these are intention to create a trust, that's certainty of intention. Certainty of subject matter is that the property held on trust must be certain enough. And for objects, the beneficiaries of the trust must be certain enough. So in this context, in analysing the investor-intermediary relationship, the crucial task is to determine whether an intention to create a trust can be ascertained from the agreement. So it's to do with the certainty of intention, because the other 2 requirements are not terribly controversial here. The object of the trust is the investor, and the subject matter of the trust is whatever crypto assets are in the trust fund from time to time. And we know that under English law, a trust can exist over a fluctuating pool of assets. Now, what must be intended is, at least as a starting point, the intermediary is not to have free use of the asset. And this is again to be ascertained primarily from the terms of the agreement. And one very important indicator of such an intention is that the asset should be segregated from the intermediary's general assets. And this tends to indicate that the segregated assets are not to be at the free disposal of the intermediary, although this is not a hard and fast rule. Another very important indicator of such an intention is whether the asset is held on the intermediary's balance sheet. If the crypto asset is being held on trust with the investors, it would not be held on the intermediary's balance sheet. And we see this in the very recent Cryptopia case. In that case, a crucial factor pointing in favor of a trust was that the intermediary, and I quote, did not assert any ownership in the cryptocurrency in its internal financial accounts. And this shows that the intermediary didn't treat the assets as their own, hence the finding of a trust. So what are the consequences of a trust being created? As English lawyers will be familiar, firstly, where the intermediary goes insolvent, its creditors wouldn't be able to access the assets held on trust, and most crucially, the investor would be able to obtain the assets on such insolvency. So this provides a very strong form of protection to the investor, in contrast with the position under outright title transfer, where firstly, the trustee's creditors have full recourse to the assets being transferred, and secondly, the investor has no entitlement to the assets. Now, a trust relationship also imposes a default set of obligations on the trustee. The trustee is obliged to use the asset for the best interests of the beneficiary, meaning that it can't put itself into a position of a conflict of interest or use the asset to make a personal profit. And also, if the trust is a bare trust, as was the case in the Cryptopia decision, the trustee is obliged to act upon the beneficiary's instructions. But again, this default position can be modified. And one may think that since the trustee is holding the asset on behalf of the beneficiary, if the trustee is given rights akin to that of an owner, the transaction would be recharacterized as an outright title transfer. And that's the case, but the threshold is very, very low in the sense that there is a great deal of latitude that the parties can have in choosing the exact relationship, duties and rights attached to that trust structure without it not being a trust. So what does this mean? So a prime illustration of this is the Citibank versus MBIA case, where a trust was upheld in seemingly extraordinary circumstances. So the trust deed contained considerable exclusions of duties that cut through what is traditionally thought of the irreducible core of trusteeship. For example, the trustee was bound by the instructions of a third party, and when instructed by the third party, the trustee didn't have to have regard to the interests of the beneficiaries when acting. And one might think that this effectively nullifies the duty to act in good faith in the beneficiary's interests. And this is a considerable exclusion on the default duties of the trustee. But despite all this, the court still held that a trust existed. So apart from excluding duties, the agreement can also augment the rights of a trustee such that he can behave more like an absolute owner. But as long as his rights aren't too much like those of an absolute owner, he can still be a trustee. So in Pearson and Lehman Brothers, it was held that even a right of use in relation to the asset given to the trustee could be consistent with a trust being in place. But again, there is a limit. If too many duties are being excluded, or if too many rights are given to the trustee, the arrangement might not end up being a trust at all, and there would instead be a title transfer. For example, the right of use becomes inconsistent with a trust where the profits derived from the use of the asset are to belong exclusively to the trustee. And here there would be a title transfer. So if we go back to Louise's example about the fork and the spade, even if you call a spade a fork, the court will still hold it to be a spade. So in this case, the fork would be the trust and the spade would be the title transfer. The court would recharacterize the trust as a title transfer, just as it would hypothetically recharacterize the fork as a spade if forks and spades are to be legal categories. But if you create an object that behaves somewhat like a fork and somewhat like a spade, and you call that a spade, the court might marginally accept that as a spade, just as a court may marginally accept something as a trust, even if the trustee has a right of use. The third possibility is a bailment. So what is a bailment relationship? So a bailment relationship is created where there is a voluntary transfer of possession of an asset with the consent of the transferee. So this is how the bailment relationship is constituted in the first place. In this context, possession of the crypto asset is required to be transferred to the intermediary. And in relation to consent, the intermediary needs to consent to two things in particular. Firstly, the presence of goods in the intermediary's possession, and secondly, the identity of the person claiming to be the bailor. This means that one can't create a bailment relationship merely by sending bitcoins to a particular wallet held to the intermediary if the intermediary doesn't consent. So what are the incidents of this bailment relationship once such relationship is created? The main duty is a duty of care. So the bailee has to take reasonable care of the goods in its possession, and we apply the negligent standard of care in this respect. So this is the main duty. So what rights are created in favour of the bailee? The bailee has title to sue third parties in tort for interference, such as in conversion of trespass, because it has possession of the crypto asset. And so we see that the intermediary has proprietary rights to sue for interference good against the world. And so in a bailment, there is this proprietary effect. And because this bailment arises by contract, i.e. by virtue of the investor-intermediary agreement, the terms of the contract govern the bailment relationship, and so there is an obligation not to deviate from the terms of the bailment. But there might be a difficulty with creating a bailment relationship between investor and intermediary of crypto assets, as Louise suggested. Under the current law, it's impossible to create a bailment of an intangible asset, including crypto assets, which are intangible. And the rationale is, since it's impossible to have possession of intangible assets, and because possession is required for a bailment, you put these two things together, it's impossible to have a bailment of intangible assets. But there is an argument in the literature, and Green and Snag make this argument. They make the argument that a crypto asset can in principle be possessed in the context of a crypto security, and this is on the basis that such assets are concrete objects. So concrete objects are objects that can be transferred from party to party, excludable, and independent of a relationship between people. And these objects are to be distinguished from abstract objects like pure contractual rights. So these abstract objects only exist because of a relationship between individuals. For example, the debt, we require a creditor-debtor relationship between two individuals. In contrast, a crypto asset is permanently on the blockchain, and also its existence doesn't depend on any relationship between any individuals, such as just like the continuing existence of this cup doesn't depend on any individuals. So all of us could die, but this cup could still exist, and the same rationale applies to a crypto asset. And to state the obvious, a crypto asset is transferable because it can be transferred from address to address on the blockchain, and also it can be excludable because you can use your private key to exclude other people from accessing it. So on this view, a crypto asset can be the subject of possession. And a very important corollary of this is that a bailment can arise over crypto assets held by an intermediary on behalf of an investor. But this is just one possible analysis, and many jurisdictions stick to the view that bailments are impossible in relation to intangible assets, and this is particularly prevalent in the civil law jurisdictions. So the term quasi-bailment might be more appropriate here to reflect the fact that the principles relating to possession are applied only by analogy with physical tangible assets, and it's not a direct correlation between the two. What about situations of shared possession then? Would a quasi-bailment arise under such circumstances? And the answer under English law is no, because what's required under the authorities is a transfer of exclusive possession. So in the case where the private key is known by the investor or is known by both the investor and the intermediary, there is no exclusive possession by the intermediary and therefore no bailment relationship. And so the final possibility is a mere contractual obligation, where there's no outright title transfer, trust, or quasi-bailment. The legal relationship between the investor and the intermediary will only sound in the contract. So the contractual obligations will be set out in the investor-intermediary agreement, and there would also be implied terms. So most notably in this context, because the intermediary is performing a service, there would be an implied term of care and skill. And in this case, in the case of care and skill in the custody of the crypto assets. And there might also be duties in tort, such as a duty of care, which runs concurrently with the implied term of care and skill. And the distinctive feature about this final possibility is that the arrangement doesn't have any proprietary effect, unlike the first three categories. In other words, no property rights in the asset are created in favour of the intermediary, and the obligation is purely sound in contract. I'll now hand over to Henry to talk about the more specific legal arrangements involving technology providers, data loss, and the regulatory side of crypto asset.
Yes, thank you. I think the contract-only analysis is, I guess, the most interesting or the most novel for digital assets. And it's particularly pertinent because this is where a lot of digital asset intermediaries would like to end up, or at least they claim that this is the relationship they have. It is contract only, and I'm really not dealing with your property at all. I'll give you a few examples. So there are simple examples, like if AWS, so Amazon Web Services, which is a large public cloud-based provider, was to maintain hardware that would store private keys representing control over certain assets. Now, this is very much how Fusang operates. We run all of our technological infrastructure on AWS, and including the private keys that Fusang holds as custodian are ultimately stored on hardware operated by AWS. But AWS does not in any way directly have access to those keys. They are effectively re-encrypted, and only Fusang has access to them. But if AWS were to accidentally or deliberately destroy all hardware that they run on Fusang's behalf, we would also lose access effectively to those keys. Now, if the asset, I guess, with typical information, I think a lot of the analysis is less controversial. AWS in most cases would disclaim any and all liability of their clients, including data loss, unless you have signed some special agreement with them, what tech providers call SLAs, or service level agreements. And this is the way that most such providers would operate, where they say, if you would like me to introduce certain rights or certain protections or certain guarantees that I have in terms of looking after your data, you must effectively pay me more money for some kind of enterprise level relationship. Is usually how these things happen. And I think it's an open question as to whether or not that analysis would still apply if the asset is property. So let's say if it was some Bitcoin and you decided that Bitcoin were property. I guess the question is, does AWS have some extra duties that get imported as a result? But still, I think this is a relatively straightforward case. So, if a client faces Fusang as custodian, it is Fusang's responsibility and liability to figure out how to actually operationalize and store that data. And we, I guess, would have that duty to face AWS and to take any proper cares, including, for example, the fact that we back up our data left, right, and center to avoid exactly that scenario happening. But I guess the question is, a little more interestingly, what if the technology provider does have direct access or control in some form over the asset? And this is the way that a lot of digital asset, quote unquote, custodians will operate. Sometimes they will say, I should not have any other duties to the client because control is split. Yes, I do have unilateral access to this asset, but so does the client. And therefore, if the client wanted to, they could control and or transact in that asset without me. And I do not want to be effectively regulated as some kind of intermediary. I don't want there to be another relationship. I am acting as a pure software provider, even though I exercise some degree of control. And I think it's, again, an open question as to how far you can get with that line of arguments. And as a third case, another interesting example is, what if the technology provider, a bit like AWS, does not have direct access to the asset if the actual private key is stored on hardware controlled directly by the client? And again, this is a very real example. A lot of so-called desktop wallets, like MetaMask, even if you've heard of it, or hardware wallets like Ledger devices, they operate in a way such that the private key is stored on hardware exclusively in the customer's control. But hardware doesn't work without software. And again, it is entirely conceivable that due to an error on behalf of the software provider, let's say I pushed a new update of the software and whoops, something went wrong and it deleted everything on your hardware. Now, A lot of software providers will again claim, no, we have no duties to our client whatsoever. We sold the client the hardware and I guess associated software, but the hardware is in the client's possession. We have no access to those keys. Therefore, we should have no other relationship than some kind of contract with the client, in which case usually you will disclaim any more liability. And again, the question is, given that through my actions or omissions, I may do something accidentally that causes you to no longer have access to your property. Even though I may not be able to transact in your property, I could deny you permanently access to your property. In that case, what does that mean? Again, I think these are open questions in a lot of common law jurisdictions, but I think it's quite interesting to see that at least in the US, there's been a proposed regulation that I think has only been adopted in one state, if I'm not mistaken, Charles, in which they sort of recognize this issue and try and think about the concept of control a little more in terms of who might have control over an asset, and more specifically about whether or not a party could unilaterally deny you access to an asset. And saying, if I could unilaterally deny access to an asset, perhaps we should also be thinking of that as a form of control, and therefore as a form of me acting as an intermediary, some kind of custodian. I think these are all open questions. Again, a lot of this is driven by the fact that a lot of intermediaries do not want to have liability or any form of role. And I guess I'll talk about that a bit later on. But I do think that in many cases, the default position that courts and or regulators will take for most intermediaries is that of a trust. And the question is, why is that? And I'll argue that practically speaking, for 95% of all digital assets out there, certainly ones that are held by some kind of intermediary, they all work in kind of the same way that will naturally lead to the conclusion of a trust. And assuming, number one, that the jurisdiction does not want to extend the concept of a bailment to intangible objects, then really there are only three possibilities as I lay out here. That number one, it is a trust. That number two, that the intermediary has title to the assets plus contract, like a bank. And number three, that it's just a contract only. I think number two is highly unlikely, because almost every intermediary will explicitly say, no, it's definitely not number two. I do not have outright title to the assets because number one, I don't want to have to deal with the accounting and tax implications. And number two, because in all of my marketing, I explicitly tell the clients, don't worry, this is still ultimately your asset. You haven't just given it outright to me. I am just holding it on your behalf. I'm providing a service. I'm looking after this asset while it is in my care on the client's behalf. So they all claim that number two is not true. And I think number three, that it is only a contract, is likewise highly unlikely, because in most cases, these intermediaries have a great degree of control, and usually exclusive and unilateral control. So the vast majority of assets in the digital asset world, or the crypto world today, are transacted on centralized exchanges, in which there is also centralized and exclusive custody over those assets, or control at least over those assets. There is no split control with the investor. The intermediary, again, has exclusive control, and I guess you could say possession as well, although obviously that's a slightly trickier term. And so I would argue that number three, again, seems quite unlikely, except in cases where they really say, no, I am just a pure software provider and you hold the hardware. But that is the vast minority of assets. And so to me, an intermediary, again, that holds assets not on their balance sheet, on behalf of their clients, where they have exclusive control of those assets, where they say, I'm holding this thing for you, the client, that sounds an awful lot like a trust. And my opinion is that, again, most common law courts and regulators will all come to that default conclusion, accepting any other arguments that the intermediary makes. The problem is none of the intermediaries want there to be a trust, and will try everything they can to argue that it is not a trust. Obviously, in the case of an insolvency, the intermediary will always argue that they had title so that they can retain control over those assets. But even normally, I know of none of the large centralized exchanges out there who claim that there is a trust relationship because of a couple of implications. Number one, obviously, is that you will have certain minimum duties as trustee, even though you could exculpate most of them. But the number two reason, and the larger reason, is that in many common law jurisdictions, certainly the ones in which, again, 95% of these operators and intermediaries are based out of, that would trigger licensing requirements. I think the one big exception is the UK, which, if you're acting, to the best of my knowledge, as professional trustee, but the underlying asset is unregulated, so let's say you were to act as trustee of art, I do not believe that would attract any licensing. Unless you were to, let's say, transact in securities, in which case you would probably need to be licensed as, let's say, a broker. But certainly in places like Hong Kong, Singapore, Malaysia, and a lot of the offshore jurisdictions in which these intermediaries operate, like the Cayman Islands and the British Virgin Islands, the minute you are acting as a professional trustee, meaning you're doing this as a repetitive business and you are doing it for a profit, you almost certainly would need to be licensed as a trustee, even if the underlying asset was not regulated. And this, I think, is particularly interesting because for, I guess you could call them traditional assets, as Louise mentioned earlier, let's say these were intermediated securities, it does usually fall that the asset is held under a trust, but this is usually not a problem because the intermediary is licensed anyway, as, let's say, a broker or a banker, etc. This is interesting because in many countries where, let's say, Bitcoin, the regulatory status is still murky at best, most intermediaries do not want to be licensed in any shape or form. And if they claim that they were acting as trustee of these assets, they would need to be licensed. And even in cases where that licensing is relatively light, you would still need to have, again, some minimum requirements, most notably around KYC and AML. Regulators have always been keen to impose these regulations on trust companies precisely because there is a huge potential for money laundering. Right? Trust companies inherently say, I am holding someone else's assets, it's not mine. And regulators always say, well, the question then is, whose assets are these? Do you even know who your client is? Again, these may sound like relatively straightforward requirements for most operators, but the truth is that is not how the digital asset world works right now. I would venture to argue that there are very few intermediaries who really could tell you who 100% of their clients are. In many cases, they adopt a staged KYC approach. I was just talking to someone last night. We say, oh, well, depending on the size of the clients, sometimes we do half KYC, sometimes we do quarter KYC, and we sort of have flexible requirements. And it's only for the big clients that we actually know their identity and know where the money came from. But I think these will all get harder and harder to get away with because certainly the FATF has decided really that most virtual asset providers do need to do KYC and AML, regardless of the nature of the intermediary relationship. And they're likewise looking at imposing things like the travel rule, where virtual asset intermediaries need to communicate identity data with each other. And I think that is sort of the crux of the issue, where right now intermediaries want to have their cake and eat it too. You know, they want to skirt the issues. They say, if we do have any contract at all, I do not want to really tell you what the nature of the contract is or what the relationship is, because they both want to exclude liability. But at the same time, they're telling their clients, don't worry, these are not my assets. I'm holding them purely on your behalf and will take your instructions as, you know, in terms of how to deal with them and dispose of them. And just one last point is that certainly I think more and more regulators, like in Hong Kong, have come to the conclusion that certainly if you are licensed, you should be holding these things in trust, but they have not as yet extended that to say, but if you are not acting as trustee, what else could it be? And like I said, my argument is it seems like the default should be a trust. It seems quite hard actually to argue, given a lot of those requirements, that this could be anything but. And in any case, what's the big deal? If you really were a financial institution and you really were looking out for your customers' best interests, it really is not that difficult to comply with the requirements of acting as a licensed trustee anyway. And so the only reason for you not to comply is if you were trying to do something a little more on the line. And so for all of those reasons, I think that more and more courts and regulators can and are indeed deciding that actually these things look an awful lot like a trust. And if there's no reason for us not to call them a trust, why not decide that this is indeed a spoon and that this should be a trust?
Thank you very much indeed. Wonderful, really, really interesting paper. Now, before I throw the floor open to questions, Guy, can you start us off with some comments?